My name is Abhas Chandra and you are watching Judgment Saga. In today's video, I will share highlight of judgment of Honorable Supreme Court of India. Pramod Suryabhan Pawar versus State of Maharashtra and another. In present case, the plea that appellant engaged in sexual relations with the complainant on the false promise of marrying her. Therefore, her consent being premised on a misconception of fact, the promise to marry, stand vitiated. There is a distinction between the false promise given on understanding by the maker that it will be broken and the breach of a promise which is made in good faith but subsequently not fulfilled. Where promise to marry is a false and intention of the maker at the time of making the promise itself was not to abide by it, but to deceive the woman to convince her to engage in sexual relations. There is a misconception of fact that vitiates the woman's consent. In order to come within the meaning of the term misconception of fact, the fact must have immediate relevance. Allegations that in November 2009, on the promise of marriage, accused established sexual relations. Complainant and appellant were engaged in sexual intercourse regularly over a course of 5 years. Appellant expressed his reservations about marrying complainant in 2014. Despite this, they continued to engage in sexual intercourse. Allegations do not indicate that promise by appellant was false or that complainant engaged in sexual relations on the basis of this promise. No allegation that when appellant promised to marry complainant, it was done in bad faith or with the intention to deceive her. Appellant's failure in 2016 to fulfill his promise made in 2008 cannot be construed to mean that promise itself was false. Complainant was aware that there existed obstacles to marrying the appellant since 2008 and that she and the appellant continued to engage in sexual relations long after their marriage had become a disputed matter. Allegations believe the case that she was deceived by the appellant's promise of marriage. Impugned judgment and order was set aside. FIR was quashed. Thank you for watching.